Good morning. Are you Daryl Barnworth?
Yes, from Burnworth.
Burnworth, and this is cause number 26 DCCR 0038. Mr. Burnworth is charged with theft of property. And that looks like it was titled a first degree felony, but it was amended for the value to be of $30,000 or more, not
Right.
300,000. Is that correct?
That's correct.
What level offense does that make it?
That makes it a third degree.
Okay, then with everyone's permission, I'm going to make that notation on the indictment. I didn't when I amended it, but that way it won't be confusing when anybody looks at it. So I'm going to take care of that. All right, so third degree felony offense of theft of property. So what is the announcement?
Judge, I have been talking with Mr. Burnworth, and there are some questions that he brought to me in regards to his criminal history that went to the offer that was made by Miss French at this time. All of his history is in Louisiana, so I just need to verify some things first.
Okay,
So if I just get a couple of weeks, I think we'll be able to get this one resolved.
okay. Any issues, Ms. French?
None at all, Your Honor.
All right, we'll reset it to either 2 or 3 weeks, depending on the dockets. All right, you can go back with the bailiff. Good morning. Are you William Miller?
Yes, ma'am.
And this is 26 DCCR 0063. Mr. Miller is charged with the offense of robbery. There was an evaluation for competency that was done by Dr. Grimsley and received that. Okay, the exam date was March 5th of 2026. The finding in that report is that Mr. Miller is currently not competent to stand trial, and that inpatient competency restoration would be warranted for him to regain competency. Is there any other relevant evidence?
Overstood, Your Honor.
Yeah.
Nothing else,
With regard
nothing
to
else from the
competency.
state. No, Your Honor.
Nothing from the defense.
Then based on that and based on the report by Dr. Grimsley, I am going to find that Mr. Miller is currently not competent to stand trial. Order that inpatient restoration is warranted for competency restoration and that he be sent to the appropriate facility for a period of not to exceed 120 days from the day you get to that facility. So Mr. Miller, you'll get sent to a hospital.
Thank you.
And they'll get you taken care of so you can understand everything better, and then we'll get you back to take care of your case. Okay? You can go back with the bailiff.
Thanks, yeah.
Yes, with Mr. Parker.
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. And that would likely include mental health treatment so that you can stay on the right path and be able to be successful. Is that your understanding?
Yes, ma'am.
Also, that there would be a dismissal in clause number 25 DCCR 0170 as part of that. Is that correct?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. All right, Ms. Bailey, I'm going to find that you entered your plea of guilty freely and voluntarily. Find again that you're mentally competent and you understand the nature and the consequence of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so we can get a pre-sentence report done. And that'll just give me more information about you, your case, and that way also everything will be in place for you to have anything that you need as soon as you start your probation with regard to mental health or anything else, okay?
Yes, ma'am.
And so we'll see you back at sentencing. Good morning, ma'am. Are you Relacia Mouton?
Yes, ma'am. Sure.
And Ms. Mouton, in cost number 25 DCCR 0907. Before we go forward, I'm going to take judicial notice of the court's file. It looks like there was an evaluation done by Dr. Capon last year with regard to competency, and that we received that report back in October, and Ms. Mouton was found competent to stand trial. Is there
Did this in January 20th.
the competency reports from October?
You found her competent January 20th. That's what my file reflects also, Judge.
Okay. Maybe we didn't get her back. I don't know why.
She didn't.
There's a lot of things there with.
Hold on.
I don't think she was ever taken anywhere.
No. So I don't know why. Anyway. Found competent based on that report. There hasn't been any other reports that I know other than the Dr. Crepon report from back in October. And so any other issues at this point with regard to competency?
No, Your Honor.
All right, so in cause number 25, DCCR 0907, Ms. Mouton, you're charged with a second-degree felony offense of assault on a peace officer. And what that means is that if you go to trial and you're found guilty, the range of punishments between 2 years and up to 20 years in prison. Do you understand? I need you to answer out loud for the
Yes, ma'am,
record.
I understand.
Thank you. And then in cause number 25, DCCR 1466, you're also charged with assault on a peace officer. This one is from August 17th of 2024. The first one that I read out was actually from May 5th of 2025. So the second one, same thing, is a second-degree felony. If you're found guilty, the range of punishments between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 1467, you're charged with the state jail felony offense of possession of a controlled substance from August 17th of 2024. And in that case, that means that if you went to trial and you were found guilty, the range of punishment would be between 6 months and up to 2 years in a state jail prison. Do you understand that?
Yes, ma'am.
And then in cause number 25, DCCR 1468, you're charged with assault on a peace officer, and this is from that same date of August 17th of 2024. Again, if you're found guilty by a jury, the same punishment range applies, which is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then the last case is 26 DCCR 0120. You're charged with possession of a controlled substance, a state jail felony from August 8th of 2024. And in that case, if you were found guilty, the range of punishments between 6 months and up to 2 years. Do you understand?
Yes, ma'am.
I have here on the tablet plea bargain rejections that you've signed with Mr. Rojas that shows that the district attorney's office has made offers in your cases if you wanted to enter pleas of guilty for 8-year term in prison and on all of those assault on a peace officer cases that would run at the same time concurrently. And then a 2-year sentence in the state jail prison on those two.
The offer was actually we would dismiss the state jails, Judge.
Okay, so there would be a dismissal in the 2 state jails with, I'm gonna make that notation.
Because I just signed paperwork refusing 2 years with both of those.
You did, so obviously the bigger cases are the 8-year terms. So what the offer is, and so that we're all on the same page, it would be 8 years TDC on the 3 assault on a peace officer cases with dismissals in the 2 state jail cases. Does that change your mind?
No, ma'am.
Okay, so you have every right to reject.
Probation.
Hang on. So you have every right to reject those offers. I just need to make sure that you understand what the possible consequences are if you go to trial,
Yes, ma'am.
what your options are if you wanted to enter a plea of guilty, and you understand all of that.
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am.
All right, we'll get them set for trial. Ms.
Can I
Mouton,
get the
Mr.
lawyer?
Just listen. Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am. I thought you was trying to make me keep him.
Well, it wouldn't be the worst thing because he's one of the best lawyers we
I
have.
understand.
So, Mr. Rojas, you're released. And Ms. Mouton will give you a new attorney. They should be out to see you very soon to begin preparation for trial. You can go back with the bailiff. Would, we're going on all of the counts, it looks like,
Yes, to enhance.
to a third. It's gonna take me a second. I'll figure it out. Mr. Bell, in cause number 26, DCCR 0139, you're charged with the state jail felony offense of theft of property with previous convictions from September 25th of 2025. The indictment alleges you were previously convicted of theft May 18th of 2018 in 2 cases, and then after that was final December 3rd of 2021. And then the indictment further alleges that you were previously convicted of the state jail felony offense of unauthorized use of a vehicle, June 24th of 2019. And after that was final, you were convicted of evading arrest or detention with previous convictions, a state jail felony, November 8th of 2021. And after that was final, you were convicted of burglary of a building, a state jail felony, June 26th of 2023. And how do you plead to that charge?
Guilty.
And are those, all of those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.
And I think. Okay, and then we have. Clause number 26 DCCR 0140. And, sorry, just. And in that case, you're also charged with the state jail felony offense of theft of property with previous convictions. And that one is from December 16th of 2025. The indictment alleges the same prior theft offenses, the two from May 18th of 2018, and then the last one from December 3rd of 2021. And then it also alleges those same prior 3 state jail felony convictions. And how do you plead in that case?
Guilty.
And again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are those prior convictions all true?
Yes, ma'am.
And then finally, we have 26 DCCR 0274. And you are charged in that case with evading arrest or detention with previous convictions from January 21st of 2026. It alleges that you were previously convicted of evading arrest or detention March 13th of 2017. And also November 8th of 2021. So this one does not list those other priors, so it just is a state jail.
It's supposed to.
And I apologize, I didn't notice that it didn't list the other priors.
We don't object to an amendment if they,
Now, the state would ask to amend. to
I'm not
include-
writing all that in.
okay, you want to dismiss that one?
I mean,
Would it, that is the,
evading arrest or detention with previous convictions.
gosh, I hate dismissing and evading.
I mean, I can reset it, y'all can file an amendment, or if you want to write it out, but that's too
Understand.
much for just an amendment. That's 3 prior
Understand.
offenses, so whatever y'all want to do, if y'all want to talk about it for a minute.
I can write them out if I need to be consistent.
Why don't you do either handwritten or typewritten if you want to get down here real quick, a notice of to enhance with those 3 in it. And then I can read the enhanced, the notice to enhance.
Okay, I'll do
Okay.
that very quickly.
I'll hold it.
Thank you.
Let's go back again.
Alan's the last one. All right, are you Jameldrin Wilridge? And so before we go forward, Mr. Lewis and Ms. Malfino approached about possible solutions to the issues that we have here with Mr. Wilridge is on probation. In 3 cases, there was a new offense that occurred while he was on probation, but before he went to ISF as a part of that probation. And what I want to know before I consider any type of continuation of probation is couple, I guess, number one, how do you have any idea how he did, Mr. Kitchen? I guess, and before you go forward, would you raise your right hand? You swear from the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth.
I do.
Any issues with regard to behavior at ISF that you were aware of?
None that I'm aware of.
Okay, when did he get back from ISF?
I'm not sure exactly. I did not receive Mr. Woolridge under my supervision until September 26th of last year.
Okay, and how has he done from then until he was incarcerated on this?
That went in and he was very cordial with me. We've had cordial bit surprised by this and the other stuff that's been going on with it.
Okay, any positive drug screens, any issues at all since you had them in September?
Mhm.
Okay,
May I just ask him one question for the clerk?
course, please.
Mr. Kitchens, you brought to my attention, and I think the clerk has also sent it to Mr. Lewis and myself. His behavior in jail is less than to be desired, correct?
Yes, that's correct.
And would you characterize that as his association with those individuals who the court is very well aware are in jail? That is a different side of him than you saw while he was out on probation under the guidance and eye of the court and his family.
That's correct. Yes.
With the understanding, I'm sorry, Judge, if
Go
I
ahead.
may, that obviously Mr. Wilders is facing quite a bit of time from this court on a revocation. And would it be your intention, along with the court and myself, to make it clear to him that if he is given this opportunity, that if he comes back before this court, that he's not looking at maybe what he would be looking at today, but probably 3 times in advance of that amount of time?
Yes.
And do you think he is capable of and understands the seriousness of what it is he's facing
I believe he does. Yes.
from your interaction with him?
Okay, well, Mr. Wilridge, this is tough for me. Because you've been given a couple of opportunities and this would be another opportunity, and I don't know. I don't want you back in here. I don't want you to violate. I want you to be successful. You've been on a decent path. But what you did and thought you got away with, things catch up with you, right? And so that one's a 2 to 20 case. I could revoke you on your ag robbery and send you to prison for the rest of your life today. The rest of your life. And based on the history and what's been going on, some big fat number is probably what you deserve. And so I don't know how to be any more clear than if I give you this opportunity with what your attorney is working out with the district attorney, that Mr. Kitchen sounds like he's willing to work with you. And if I go along with this and leave you on probation and put you on a new probation, if you're back in front of me, there will be absolutely no argument about continuing probation or some low end of the punishment range. That won't be what's happening. Do you understand? You're going to be on 0 tolerance. That means no mistakes on probation. You've been on it long enough now to know how to be successful or not on probation. And if you just live your life right and do what you're supposed to, that shouldn't be a problem. It's only hard if you're doing the wrong things. Does that make sense? All right, y'all can do the paperwork.
Thank you, Judge.
Thank you.